Hey everyone, welcome to the live stream this evening. So happy to have you here. Always good to spend a Tuesday evening with some of you guys. And tonight we do have John Ross. He's waiting in the wings. We're going to talk about a lot of estate planning stuff, but let me do some real quick housekeeping stuff first. So one of the things that I always intend to mention, but never do, I don't think I have yet anyway, is in the comments. We absolutely want to have your questions. We want you to put those questions in there, and we want to be able to answer those questions. But to make sure that everyone understands the context of what we're answering, we like to show those questions on the screen. So if you don't want your name or your YouTube handle displayed, you may not want to put a question there, because it is our intention that when we answer that question, we're going to put it up on the screen. All right. You know how we always start these? I always love to hear where everyone is from. So in the comments, if you would drop that in there, while we're waiting on a few more people to join, that would be great. Always love to see if we can hit all 50 states in one live stream. We've got somebody from Missouri, Alabama, Florida, Pittsburgh, San Antonio. I would say it's just down the road, but we're in Texas, but that's not really just down the road. Cincinnati, Oklahoma, Little Rock, Arkansas. That's Doug. I know Doug. Tennessee, Houston, Tennessee, Washington State, Mississippi. Goodness. From Canada. Cyprus. Oh, we've got a good number of Texas folks in here tonight. Indiana, New York. Excellent. Love it. Garland, Texas. Now that is just down the road. A couple of hours, maybe 3. Some Florida folks. Another Georgia, Louisiana, El Dorado Hills, California. Hello, Michelle. It's good to see you on here. Glad you're here. Kentucky, North Carolina, Volcano, California. If that's how you say it. I hope it is. Idaho, Oregon, Louisiana. Well, fantastic. Let's dive into this. We are just about at that 500 mark that's joined the live stream now. So I think we have waited long enough. Now, for those of you who have been around for a while, if you've listened to the podcast, you know who John is. John is the co-host of the Big Picture Retirement Podcast. He and I have been doing this podcast since 2017. It's been almost 10 years at this point that we've been recording this podcast. But today, he's going to join us. He's going to dispense some of his elder law and estate planning wisdom on us. John, welcome to the YouTube channel.
Howdy.
Glad to have you here. And for those of you who listen to the podcast, you'll also recognize howdy.
That's right.
One of the things we do. All right, John. Now, let's not belabor this. We're going to have a lot of questions. I already know that.
Yep, I'm sure we will. In fact, we've already got a few there.
Yeah. And I see the chat roll moving on by pretty quickly. So some of the time while you're talking, I'm going to be looking through some of the comments that are in there to make sure we get the good questions out.
All right. Sounds good.
One of the things that I want to make sure that we do is to not go too deep into the legalese, right? You attorneys are known for that.
Nah.
Although you're not. You don't do a bad job of that. You never have on the podcast. But I want to make sure that we keep this pretty surface level. But, one of the things that that I'm asked, there's like this list of questions that I'm asked all the time. Right there at the top is like, Devin, what's the best age to file for Social Security? Right? Or do you think I should do Roth conversions? Or what's going to happen in the market this year? Right? Those kind of questions. Those are some of the big questions that I get asked all the time. And I know you have to have a list like that as well.
Oh yeah, for sure. I do.
And that top 5, I would bet. Now, I didn't ask you this before we came on here, so you may say, no, not really. But I would bet that in that top 5 is, John, do I need a will or a trust?
Yep. Yeah, no, in fact, when clients come to the office, we have them fill out a little form, like you do at the doctor's office, right? Put your name, put your date of birth, put your address. What are you here to discuss? And I bet at least 2 out of 5 will say will/trust ?
Yeah.
Yeah. I mean, so yeah, I mean, it's a top 5 question. No question about it.
So when people ask you that, they say, do I need a will or a trust? What is it that they're really asking?
What they're really asking is, hey, I need some explanation because I just don't know what's appropriate for me. In fact, most of the time they don't have any idea what they're even talking about. They've heard these terms, right? They've heard, everybody's heard, oh, you should have a will. You hear that anywhere you go, anywhere you look, but then they've been on the internet or something and they've seen stuff about a trust, and maybe they think a trust should be better. They don't know. Maybe they're just convinced that they need a trust for some reason. Their friend told them, oh, you got to have a trust. So that's, they're coming in to figure out what is it that I need.
All right. And so
what is it?
They have filled out that form, and now you are sitting down in your conference room and you're talking to them. How do you walk through leading that conversation among the features and benefits of each, and then helping them arrive at that decision?
Well, what I always joke about is like the will, if we just start with a will. So first of all, what does a will do versus what does it not do? A will controls the assets that go through probate. So if for example, I have an IRA, you mentioned IRAs earlier. If I have an IRA and I've named you as a beneficiary, that's going to go to you, period, according to the beneficiary. Even if I had a will and my will says I leave my IRA to my cousin Freddie over here, you would still get it because that passes to you according to the beneficiary. That's a non-probate transfer. So first of all, my will is only going to control assets that are part of my probate estate. 2, my will is not going to be valid in any state in the United States until 2 things have happened. I have died, and that will has been admitted to a court. Right? You hear about, well, I heard, the will's got to be witnessed and it's got to have a notary or all of these things. Well, all of that is proven after your death by a judge. That will is presented. They figure out, is it a valid will? Yes, it's a valid will. The judge stamps their seal of approval on it. Now you have a valid will. Presumably it appoints an executor. That executor can gather up only those assets that are part of your estate. Because again, anything with beneficiaries or joint tenant with right of survivorship are going to go otherwise.
Right.
And then they're going to dispose of it according to the will. So, is having that will better than nothing at all? Okay, great. But, I often joke, I say, well, the one thing about it, the will's easy on you. Yeah. I need you to do 2 things, right? I need you to sign the will and die.
Yeah, right.
And then it's going to be somebody else's problem. And they're going to deal with all of those things, right? But that will did nothing for you while you were alive. In fact, it did nothing for you as far as death. It certainly didn't make the transition at death any easier. And so then you start looking at, well, what are the alternatives to will-based planning? And that's where you get into the discussion about trusts.
So what is it exactly that good grief, man, these questions feel almost scripted that I'm asking you. And if anybody's followed the podcast for a while, we don't script out anything.
No. Anybody that listens to the show knows our preparation was about 4 minutes before we hit the go live button.
It may have been at the Keurig while you are making yourself a cup of my coffee.
That's possibly so.
Yeah.
While you complain about the cost of the K-Cups.
Yes, they're 44 cents now. It's ridiculous. So the question I was getting ready to ask you was something to the effect of, now I've lost my train of thought, but I think what it was is, so you got all these people asking you, should I get a will or should I get a trust? But what exactly is it that a trust will do that a will won't do?
Right. So then let's talk about a trust, right? So first of all, saying the word trust is like saying the word surgery, right?
Gotcha.
I can go have a hangnail removed. I guess that's technically a surgical procedure if I have a doctor do it, right?
Yeah.
I can also have a tumor cut out of my brain by a neurosurgeon. That's also surgery. Those are two different types of surgeries.
Yes.
They accomplish two very different goals. So saying the word trust is like saying the word surgery in the sense that they do very different things based on what the words on the page say. However, they're all going to have several things in common. Every trust out there is going to have the people that create it, referred to generally as the grantors or settlors or trustors. You'll have the people who are in charge of it, the trustees. That's who's going to manage these things. And then you've got the beneficiaries. That's the people that receive the benefit of the trust. So all trusts are going to have those three things in common. Once you have created this written document, stack of paper that has people that create it, people in charge of it, and people that receive the benefit of it, my best analogy is that what you have now done is you have created a legal bucket.
Okay.
The nice thing about a bucket is you can put things in the bucket, right? So I can have my brokerage account in that bucket. I can have my real estate in that bucket. I could have my ownership interest in business entities in that bucket. I can pretty much put just about anything in that bucket, just about. And then the idea is that bucket, maybe I'm creating it for myself. While I'm alive, I can manage it. I can do with it what I want. If I become incapacitated, somebody can immediately, because I have designated a successor trustee to somebody to be in charge, somebody can now immediately step in and manage all of my assets because they're all in the bucket. When I die, everything's in the bucket. Everything passes according to the words on that page. That happens according to the trust itself. So that's a nice smooth transition where my successor trustee, who has everything in the bucket, can now distribute those assets among my beneficiaries. And I could even go further and build in some stuff in that trust related to protecting those beneficiaries, maybe keeping the trust going for another generation or multiple generations, right? So that's going to be your real big picture, right? Your typical trust is going to be something that I'm creating, often for my own benefit while I'm alive, then to transfer the assets at death smoothly, easily, cost efficiently, and then possibly to provide additional protections for my beneficiaries, all within that one trust document.
So if I could sum this up somewhat in layman's terms, if I think what I'm hearing is correct, now this has always been my understanding in the conversations that you and I have had over the last 9 years in the podcast, is the real difference between a trust and a will then is the simple fact that it gives me a way that somebody can step in while I'm still alive. A will won't do that, right? They can step in and manage my affairs some because of those assets that's in the trust. A successor trustee could come in. But secondly, it gives me some control once I die in how things can be paid out.
That's right. And without having to deal with any sort of court supervision,
right?
Without the situation where you have probate assets and non-probate assets, because the idea is you get everything into that bucket.
Yeah.
Right.
And that's one of the big fears that a lot of people throw around out there too. So years ago, there were I don't know if you call them scams or not, but I think that's how we referred to them. Living trust scams, right?
Living trust mills is what they were typically called. Living trust mills.
Yeah. They would come around, they would do a steak dinner at the Golden Corral or maybe somewhere even nicer. Yep. And, they would pitch you the need for this living trust. Because if you didn't do it, then your assets were going to have to be probated, and that was going to cost hundreds of thousands of dollars. This is the way that would be positioned.
Yes, and all these taxes and all these other things that were going to be bad. And essentially they were, so there was a big class action lawsuit against the one of the biggest living trust mills out there. I was the I was the expert witness in that class action case. I have sat through those Golden Corral presentations. But yeah, they were using the living trust, which is a valid tool, as a way to ultimately get into your financial information, sell you high commissioned insurance products and things like that, right? So it wasn't that the product itself was bad. It was that they were using what was otherwise a good product to scam them in other ways, right? That was kind of the whole deal there. But to your point, what people ended up with was a pretty binder.
Yep.
That, going back to my analogy, was basically an empty bucket. Right. So that's actually one of the, and you'll even hear a lot of attorneys, some in the estate planning field, who are very antitrust planning. And they will say that the reason is because that so often the clients do not fill their bucket. They think they want a trust, they give them a trust, that the client never actually goes through the process of funding the trust. And so when they die, they have this empty bucket. And that does, I mean, I'm not saying that doesn't happen, but that's also part of becoming, that's also where the advisor and the attorney should be coming in and assisting with that. Like for my clients, we always prepare the deeds and get all of that. We assign their personal property. If I know who their financial advisor is, I'm often dealing directly with the financial advisor to get their accounts retitled. There's some things I can't do. I can't go to their bank and say, hey, bank, put the Smith's CD in the name of this trust. So I do have to rely on them to do a little legwork. But I often try to make sure that they do understand that, yes, you do have some jobs to do. You've got to fill up your bucket.
Right. Yep. And it's amazing to me how many times we'll have someone that will come in with a trust document and say, I don't really know what to do this to, what do I need to do with my accounts here? And they just didn't get good enough instructions from their attorney about what to do.
That's right. That does happen.
And it's, sometimes it is a bit of a hassle to have to do that if you have, extensive holdings that you.
Well, but again, it's going to be a hassle regardless, right? Yeah. One of the things I always try to explain is, especially like if I'm talking to a husband and wife, or somebody's, it's mom and she's brought in the kids and we're having this conversation. And I try to explain to them, look, all of this transferring that we're talking about is going to happen. You can do it now at a leisurely pace and get everything into your trust, or you can wait, and then after the person dies, while you're grieving, via probably a court process, you can do all the transferring. Right? Which would you like to do? And I will say almost universally, the clients say, well, yeah, I mean, I'd rather get it all taken care of now. They understand that's going to be a little work. But again, we've had that conversation. We've explained those things so that they know that there is actually work to do. It's not just sign the trust and die. Right. It's sign the trust, fill up the bucket, then feel free to die after that.
Yeah. So there are also some attorneys, on the other hand, you mentioned the attorneys who are antitrust, but I have ran into the attorney that is the trust is the Swiss Army knife, right? It does everything in their opinion. And if you go into their office, you are going to leave with a trust.
That's also true, and that's also wrong, right? Yeah. When I give speeches and the question comes up, from an audience member, and they'll say, well, which is better, a will or a trust, and I often say, look, it's not a one or the other sort of deal. A trust is appropriate for some people. A will is appropriate maybe for some people. Neither is also appropriate for some people.
Right.
I mean, if the only thing I have in the whole world is a bank account, I mean, I could probably just go and name payable on death beneficiaries and be done with it.
Yeah.
Right. In which case I didn't need either of them,
Right.
Now, again, there may be other circumstances that I need to factor in. Do I need to protect those assets for myself while I'm alive in case I go to the nursing home, or if I get sued? There's some issues, right? Maybe I want to leave it to my child, but my child has MS, and while they're not currently disabled, they may very well be in the future. All right, we've got another hiccup there, right? And so, it's got to be very person specific. I've also had that clients where I've explained the benefits of the trust, and in the end they say, well, I'll be dead. What do I care what kind of headache they have?
Right.
That's just that's less work on me, and I'll be and while I'm alive, which I like, and hey, I'm cool with that too, right? So yeah, it's not. First of all, there is no one size fits all, and again, even if just going back to my first point, just saying the word trust is not, because every person who has made a comment here, right? If I were doing a trust for every single one of them, no two of them would look alike. Right? Some might be revocable, some might be irrevocable, some might have tax plannings, others would have different tax planning. All of these things are going to be different based on their individual situations. Some may be worried about long-term care costs, some may not. Some may be worried about the death tax, some may not. All of those things have to come into play as you're designing the appropriate type of trust for that individual client.
So it's not just some software that you have that you fill in the blanks and hit print.
Well, and is there software? Yeah, sure. Do I use software? Yes, I do. But, I haven't counted it up exactly. But for example, in some of the software that I use, there's something like 1,000 different options that are built in there, as far as design choices.
Yeah.
Because there's just so much to it. Now compare that. Can you download some software or get on some sort of website where you can get a trust? And yeah, they're going to ask you 5 basic questions like your name and who the names of your kids are and who do you want to be your successor trustee, right? That's basically the online version of the living trust mill.
Right.
And you didn't get, instead you had to pay for it. You didn't get the free Golden Corral steak.
Yeah. Well, and I said that with a laugh earlier when I talked about just some software, because I remember you and I were talking about a story where I think you were reviewing it was either a will or a trust one, and the attorney that drafted it had left the web address at the bottom where he had printed it off.
Yeah.
Website. It just printed the screen and still had all the information on the bottom.
It really did. Yeah. It still had the website address across the bottom on the footer of where he had printed it off.
Freewills.com.
Yeah. The clients were less than impressed.
Yes. I'm sure.
Yeah.
I'm sure they were. Well, we've got tons of questions that's coming in here. And at the end of the day, I think the wills versus trust is going to be just highly personalized. And so maybe getting into some of the questions.
I like it. Yeah. I mean, I think, hey, that's what the people want to hear, right?
Yeah. Before we get there though, let me ask you this, because this is one thing I'm running into with the clients that I consult with, most of who have saved a lot of money, but they haven't always paid close attention to their estate planning. And sometimes they will say, well, we haven't had our will done since the kids were little. And now their kids are, in their late 20s or 30s. So, if someone has let's say legal documents that are 10, 15, 20 years old, what would your advice be there? Should they ignore those, update them, or should they just start over?
Well, so first of all, they should definitely have the conversation every so often. Now, what is every so often? That's going to look like a curve that goes up like this, right? The difference between a 45-year-old and a 55-year-old, that decade, maybe not entirely different than the decade from 55 to 65. Yeah. But the decade from 65 to 75 is a different decade. The decade from 75 to 85 is a different decade, right? I mean, they're still 10 years, but they're the shorter periods of time.
Right.
And so, can somebody get away from that? Yeah, they did their estate planning when they were 45 and now they're 65 and they haven't had it looked at. Sure, that's probably fine, but I bet there's things that are going to need to be changed. And from 65, they probably need to take a look at it again, maybe at 70, definitely by 75, but they don't need to be waiting another 5 years after that, right?
Yeah.
Because all of a sudden you don't have the kind of time where law changes that you've never heard about might impact your situation. Things that, newer design features. Estate planning attorneys do happen to tend to be kind of creative, and we come up with new concepts. There are things that I put in trusts today that didn't exist when I started drafting trusts 20 years ago. Certain concepts, certain positions, things like that. So, So, I mean, you do want to have that looked at frequently, and the older you get, the more frequently.
Well, let's jump into some of these questions, and I'm going to have to scroll back up to the top. And guys, if I miss one of your questions, just put it back in there. There's a lot here. I don't know how many we have, but there's a lot. And also, I want to give this disclosure while we're talking. So John and I have known each other for a long time, 20 years now. He and I have never had a relationship where he pays me to send people to him or vice versa. There's no kind of affiliate relationship here where, he's not paying me to be on this show. Although, John, you probably should. There's some kind of remuneration.
I'll bring some K-Cups over to your place.
Yeah, some K-Cups. That would be a good gift. Some good one, like some Black Rifle Coffee K-Cups.
Okay? All right. You got it.
Member's mark. But, I do this because John has done my estate planning, and he's done the estate planning for a lot of my clients. And I do completely trust his work. And I would tell you that if you want to talk to John a little bit more, there's a QR code that I just put up in the top left-hand corner. You could scan that QR code. That'll take you right to his calendar. And you can book. I know most of you are watching by YouTube, but Zoom, he's got a Zoom option on there, and you'd be able to do that. All right, let me get back into some of these comments. Woo! I'm going to have to put my glasses on and get the glare going. All right. Goodness. Where do I start? All right. How about this one? She says, if I become incapacitated, which tool actually protects me better? A trust or well-drafted powers of attorney?
Yeah. So first of all, you're going to need both.
Okay.
Right. And just from a very simple standpoint, your cell phone contract, there's nothing about your trust that involves your cell phone contract. And if you're incapacitated and somebody needs to go to Verizon and cancel your cell phone service, they're going to need a power of attorney, whether you have a trust or don't have a trust. Right. Now, from there, first of all, I do think that the trust will generally, because all of your assets are contained in the trust, if you're incapacitated, your successor trustee immediately has access, and all they really have to do is show them that they are now the successor trustee, right? Whereas with that power of attorney, I have found banks and other financial institutions to be very leery. Just this morning, we were trying to call this annuity company with a client. They have to send the power of attorney in. It's going to take a couple of days at least for them to review that and get back to us to whether they're going to honor the power of attorney. Whereas if that annuity contract had been in the trust, we could just send them a certification of trust that says this lady's the trustee and she's going to be able to do all the things. So from that standpoint, much better. Also, depending on the design of the trust, and this actually goes to some of the other questions, I think, but a trust can be structured in such a way that if you are incapacitated and need assistance with things like maybe in-home care or nursing home care or assisted living, it's possible to use that trust to shield those assets so that you could be eligible for government assistance programs like Medicaid without having to exhaust your resources down to zero before you could ever qualify for those. So certainly if you're looking at the trust as not just a management vehicle, but also as a potential asset protection vehicle, then it definitely is going to sling over onto the trust side of which is better.
Excellent. Very good. Well, thank you for that question, Shay. And let's see. Get my glasses on. Oh, another question. All right. In a situation where most assets are IRAs, Roth IRAs, and taxable brokerage accounts with beneficiaries already named, what problem does a revocable living trust actually solve that a will does not?
Hey, Devin, you could answer this one.
Well, I'm not.
No, but you could tell the story about what happened to your client where they had their two sons named as beneficiary, and shortly before your client died, one of those beneficiaries died.
Yeah.
And sure enough, it actually all ended up going to the brother, and the kids of the deceased one are totally out of luck.
Yeah.
Right. And that was because that was built into a contract with the brokerage house. Right. And what a lot of people don't ever realize is they have no idea what any of that stuff says. And so what you can end up in a situation is where maybe the IRA over here with this organization, if there's a predeceased beneficiary, it goes one way. Over here, there's a predeceased beneficiary, it goes a different way. So there's all of those issues. Plus, when you're saying, okay, I'm going to name, like I've got 4 kids, right? And I'm saying I'm going to name my 4 kids as the beneficiaries. I'm making a huge assumption. And that huge assumption is that my kids at the time of my death, at some indeterminate time in the future, are all going to be alive, healthy, well married, financially stable, debt free. Basically, they're going to be perfect.
Yeah.
But if they're in the middle of a divorce, being sued, filing bankruptcy, have become disabled because of health or car wreck or something, if they're dead, all of these issues, none of that is covered with those beneficiary designations. All of it is covered in the trust.
Very good. Excellent. All right. Now, here's one that may go back to something that we were talking about. So she has a car, Social Security, and a pension, which is going to completely stop when she passes, and then her personal household belongings. Do I do a will or trust?
And this is the neither.
Yep.
Right? First of all, depending on where Andrea here lives, in many states, you can actually name a beneficiary on your car. Mm-hmm. I know you can in Texas and Arkansas, 2 primary states where I see most of my people, although I do see people from all over the country. So just because you're in, New York City or something, feel free to call and ask questions or if I can help. But, and when it comes to your stuff, frankly, here's a great suggestion, Andrea. Go to the office supply store and get if you ever go to a garage sale, they got those little stickers and you can write like 5 cents, 10 cents on them, right? And they come in 3 or 4 or 5 different colors. Go get you a couple of packages of those. Stick those on everything in your house and then make you a key and say, Sally, you're red. Billy, you're green. And then when you die, they just come into the house and they pick up whichever one has their color sticker on it. There's really no
way to handle it.
Or write it out or something like that. Frankly, but you don't need either when you're talking about disposing of your personal property.
Yeah. Excellent. Now, this is something that you just said a moment ago, but it's our next question from Dan. Does the will and trust have to be done in the state you reside in? And I think there's some more nuance in that.
There is, but the short answer is no. Now there might be, and that's often common, but for example, certain states like Nevada, Wyoming, even Arkansas now have what are called domestic asset protection trusts. You can use the laws of a state like Nevada, even if you don't live in Nevada. You do have to have a Nevada trustee to utilize those laws. There are other states like North Dakota that allow assets to be in trust forever, no end, right? And so you could create a trust that's governed under the laws of North Dakota if you wanted that trust to last forever. So although typically you would create a trust under the laws on the state you reside in, that doesn't mean you have to, and there can be very good reasons why you wouldn't under certain circumstances.
Very good. All right. Let me get my glasses back on because I cannot read this. Here we go from Colleen. She's worried about her house.
Yeah, you know, a lot of states have a transfer on death deed. That's the TOD that she's referring to. That may be called a beneficiary deed, may be called a transfer on death deed. She says New Jersey doesn't have that. Some states do, some states don't. What that is just a way to name a beneficiary on a house. Her question is a trust the answer? If your goal is to avoid the necessity of probate to clear the title to that real estate, a trust is a very simple way to accomplish that. In that case, it may not necessarily need to be a very complex trust. It could be a very simple trust that's designed basically to address the home. For example, I have a very simplified type trust that we often use when the only asset is a house. They don't need the complexity of a more expansive trust. They just want to avoid the necessity of probate, and they're in a state that doesn't have a simple solution like transfer on death deed. And so, yeah, it could be. And very well maybe, especially depending on where you are in New Jersey. If you're in one of the major metropolitan areas where the court systems are significantly backed up and the probate process is onerous, it very well may make a lot of sense.
Yeah. Yeah. Very good. There is let's talk about this for a moment.
Yeah. So generally you can put just about anything into a trust with one big exception, and that is going to be your qualified accounts. And by qualified accounts, I'm talking your IRAs, 401ks, Roths, SEPs, Simples, 403bs, all of those sort of things. For IRS purposes, you have to maintain those in your own name. Now, if the trust is properly structured, and that's a big, fat, capital italics and bolded in, you can name the trust as the beneficiary, and the beneficiaries of the trust still get the same tax treatment that they would have had they received the money themselves, and they may even be able to keep it in trust. So while you can't transfer your own qualified account to a trust, you can have inherited qualified accounts in trusts as
Perfect.
long as the trust is structured correctly.
Now, here's one that we've talked about on the podcast before, because this is always a concern, right? You have a house, and we see what real estate prices have done over the last few years. They've gone up. Well, now I want to take this house and move it into a trust.
Right. Yeah. So is that some sort of taxable event? As long as the trust, again, goes back to trust structuring, but generally no. Most of the time, you're talking about trust that you're creating for your own benefit. Those are typically what are called grantor trusts, meaning that for tax purposes, they're still treated as yours, everything in the trust. And this can be true both with revocable and irrevocable trusts, right? So they can both be treated for tax purposes as if they're yours. And so it's not a sale. You're just transferring your asset to a trust that you're the beneficiary of. That's a completely tax neutral event. In fact, if you look at if you look at a lot of the transfer forms, like if you're filing a deed in California, you have to put a form on top of the deed. And, it's questioning whether or not they're going to get to tax you or reassess your property taxes. And right at the top, there's a button for, trust that you're a beneficiary of. And as long as you check that one, then there's no transfer taxes or anything like that. Still got to pay the filing fee to record the deed, but they don't reassess your property taxes or anything like that. So no, It's generally not going to be a taxable event unless you are trying to do that for some reason.
Perfect. So here's another question that that I've gotten before, and address that.
Yeah. So I have never found an insurance company that has a problem with insuring a house that is in a trust. I have found lazy insurance agents, but I have, but actual insurance companies. I have not found insurance companies. Now, do they want to know about it? And first of all, every insurance company will do it a little different. If the house is in the trust, some of them maintain the existing policy. Some of them want to name the trust as an additional insured. Some of them want to redo the policy so that it's in the name of the trust. Some of them want to redo the policy in the name of the trust and then list the owner as a secondary insured or some other thing. But typically the agent, and again, most of my experience with the agents is that they're happy to make all of that happen. They just do their little thing. The few times where I've had a client that said that they had a issue with their insurance company, it really wasn't the insurance company. It was their agent just didn't know what they were doing or just didn't want to do it.
Yeah. So this isn't a question, but a suggestion. And it's how about discussing a checklist for when a will or trust is best? Now, we don't want to dive off into that, but when I saw that, John, that's the perfect thing that a aspiring content creator would create. How many people would download that? That would be.
That's actually not a bad idea.
This is where I get a lot of my ideas from comments and questions from my audience.
Yeah, no, that's actually not a bad idea. But I'll hit you with a couple real quick. If you have no concerns about yourself, and by that I mean you're not concerned about any sort of personal liability, you're not concerned about your personal incapacity, you're not concerned about your ability to pay for long-term care. Any of those sort of issues, right? You're just completely comfortable with all of that. You also are comfortable with your assets passing at death, potentially with more work on behalf of the beneficiaries.
Mm-hmm.
If basically all of that is true, then you may very well be leaning toward a will. And my grandfather, 92 years old when I did his a will for him. I wasn't worried about any personal liability. I wasn't worried about long-term care. I wasn't worried about management of his assets while he was alive. I needed him to sign the will and die, kind of like I described earlier, right? And I knew that I was going to be able to help my dad and my aunt through the transition and getting everything retitled, and we did have to probate his will in Granbury, Texas, and we did all the things, right? But in his case, it really leaned more will side, right? Based on all of those facts and circumstances.
Yeah. Perfect. Let's see. Now, this is a rabbit trail. We could go down this and spend some time here, I know, but why don't you hit this real quickly?
Real quick. Something that nobody's ever heard about. For example, there's something called a supplemental needs trust. Supplemental needs trust, for example, if you had a kid with, say, Down syndrome, and you wanted to leave assets for the benefit of that adult disabled child without impacting their government benefits, right? That's a supplemental needs trust. They've been around for years. Go all the way back to 1995. And in 1995, they amended the Medicaid rules to allow a spouse to create that type of trust for their surviving spouse. So if Ed here were to, in his planning, will, trust, whatever his planning is, but if his planning said that if I die, I leave everything to my wife, so it goes into a trust for her, so that she's protected, there's that tool, right? That could be a supplemental needs trust for the benefit of his wife. I guess if he's worried about him going to a nursing home so that she doesn't go broke, there's all kinds of things. Maybe shielding those assets with a trust so that they won't count towards either of your eligibility for government benefits. There's also some spousal spin down rules
Right.
So often with the Medicaid, you can shift assets from the nursing home spouse to the healthy spouse within the Medicaid rules and still preserve, in many cases, all of the family's assets. That becomes very personal, person specific, very state specific. But the short answer to Ed's question is that there are lots of ways to do it.
Excellent. Perfect. Now, this is also a bit of a deep question here, the difference between trust. And, I think this is a good time for me to say there's so much difference between trusts that it's one of the reasons I don't dip my toes too deeply into estate planning. John, there's a lot of CFPs out there who think they are armed with enough knowledge to figure out what a client needs in terms of estate planning, and then just call an attorney and say, hey, I need you to do this, this, and this for him. And I've heard a lot of them say that. But I've been around you long enough to know that there's a lot of hidden nuance there, and there's a lot of different avenues that you could go down. And for that reason, I know enough about it at this point to know it's not an area that I need to be dabbling in. It's not a dabble area at all.
Yeah, but to the guy's question, I mean, the difference between trust. I mean, think about a stack of paper. Maybe it's 20 pages, maybe it's 40 pages, maybe it's 60 pages, whatever. It's a stack of paper. Every word on every page of that stack is going to have a meaning, and it's going to accomplish a goal.
Yeah.
Right? Change one word in there somewhere, and it changes the entire trust and everything that it's attempting to do. Right? And so to that extent, then the difference between trusts is the difference between every word on every page. Because you're going to be tweaking each one of those words to accomplish the goal of that particular client.
Yeah. But then the kind of, if you broaden out from that, you also have the kind of standard revocable living trust. And then you've got lots of other ways of doing trust planning.
Yeah. I mean, you can start breaking them down into categories. You can say, well, there are revocable and there are irrevocable. Although revocable means one thing, irrevocable, nobody has any idea what that actually means, because irrevocable does not mean what you think it means.
Yes.
It does not mean irrevocable. Right off the bat, irrevocable does not mean irrevocable. It certainly doesn't mean unamendable. Right. So yeah, it really is all about the words on the page.
And that ties up some to the next question. Is the main goal of a trust protection from legal? I'm not sure if I need a trust. So who needs a trust and why do they need it? Everything my spouse and I own have beneficiaries, TOD or POD. So let's address especially that first sentence there, because that is a common misconception that a lot of people think if they put their assets into just a standard revocable living trust, all of a sudden they are somehow invisible, because there are some YouTube attorneys out there who are spreading that sorts of nonsense.
Yeah. So generally a revocable trust does not in and of itself provide asset protection. So if Enjoying Life here had a revocable trust and were to be sued, that trust, if somebody wanted to dig deep enough, they're going to be able to get into a revocable trust. That's clear as a bell. There's no question about it. Is there still some anonymity that might make it more difficult for them to discover assets? Does sometimes just the word trust, the statement you said where many people think that any trust is an asset protection vehicle, that thought is actually also within many of the plaintiffs' attorneys. Mm. I've got many plaintiffs' attorneys as clients, and many of them, just when they came in, they thought a revocable trust was an asset protection vehicle. And so presumably that means they had plaintiffs that they had represented that maybe they did not go after assets that they could have, they just didn't know. So does it have maybe some, but if somebody looks deep enough, no. But no, it's not the only goal, is protecting from lawsuits or things like that. There can be, that can be one of them. but there could be many other situations. Again, just like in this, I have beneficiaries, I have TOD, I have POD. Yes, two people who are alive and healthy and well married and not in the middle of a divorce and not dead and not disabled today.
Right. Yeah. Okay. What about IRA or other qualified assets like 401ks, things like that? Can they go into a trust?
They can upon death if the trust is structured properly. There can be very good reasons for that. So in many states and under federal bankruptcy laws, IRAs are often protected assets from creditors. That rule does not apply to inherited IRAs. So if you have a beneficiary who has, again, legal problems, tax problems, they owe people money, they're in bankruptcy, they're being sued, maybe they're on government benefits or things like that, having that IRA payable to a trust that would be for the benefit of those kids or whoever they are. Now they still get the IRA, they still get the same tax treatment, but those inherited IRAs are wrapped in this asset protected bubble so that it's not subject to that divorcing spouse or that bankruptcy or things like that.
Perfect. All right. Let's talk about the cost. It's one of the things that we are always transparent about these sort of things.
Yeah. So let me answer the last part of this question. And is it dependent on how many assets are being added to it? So I would generally not recommend going to any person who would be charging a fee for their services based on the value of your assets. I mean, frankly, that's the same thing with you, Devin, right?
Right.
I mean, what you do for a client that has $1 million invested with you and what you do for somebody that has $2 million is not double the work.
Right.
You should not get double the fee. That's why you charge flat fees. It's a great idea. We also do the same thing. We charge flat fees, and that's not based on how many assets are going into it. Now, do the fees vary based on the complexity of the document? The trust that I might create for the lady in New Jersey that only has a house versus the trust that I might create for somebody that has a taxable estate, i.e. in excess of $15 million, or the one for the person that has a child with a disability like Down syndrome that we need to make sure he's protected for the rest of his life. Yeah, so it's going to vary based on complexity. Costs, I mean, that can be a wide swath.
Yeah.
If you wanted to hit an average, call it $4,000 to $6,000 for and that would be like, that's the trust, that's deeds going, transferring real estate, that's companion wills and powers of attorney and things like that. But have I done trusts that cost $750? Yes. Have I done ones that cost $20? Also, yes. Right. So, yeah. There's a wide range in there.
Perfect. And here's a question on taxation.
Yeah. How does a trust affect how taxes are filed? So a grantor trust where you create it, you're in charge of it, and you're the beneficiary of it, revocable or irrevocable. But if you're creating it, you're in charge of it, and you're a beneficiary of it, doesn't even have to have a separate tax ID number. It can use the grantor, the person that creates it, social security number, in which case, like, Devin, for example, you have a trust. It's an invisible to the IRS. It uses your social security number. You get a 1099 from your brokerage account showing interest and dividends. The name on the 1099 is the trust. The tax ID number is your social security number. You report that on your 1040 just like you always did. Right. Didn't change a thing. Now, there are other trusts that are taxed differently. And so that's always a question. That should be one of the discussion points in a client meeting is the taxation of the trust. Some trusts do have to file tax returns, but Not all of them. In fact,
Excellent.
not even most of them.
You know anything about a Florida community property trust?
Yeah. So, several states, Texas, Florida, Louisiana, Wyoming, I think, community property states. In community property states, when one spouse dies, the assets get a full step up in basis, right? So the idea is like in Texas, if I own a house, we bought it for 100,000, it's worth $1 million, and I die, my wife gets a full step up in basis to 1 million, not just my half. If we lived on the Arkansas side, which is a separate property state, then if I died, my wife's basis would be 600,000 because she'd get half of a step up,
Right.
Because that's a separate property state. So one of the ideas is to create a trust. One concept that's flown around is this, quote, community property trust. And this is where you create a trust, you make everything in the trust governed under the community property laws of a state that is community property, Florida, Texas, even though you don't live there, right? So you live in Nebraska and you're going to create this trust that's governed under Florida law and everything's going to be community property. The idea is being able to get a step up in basis when the first spouse dies. It's not actually even necessary to do that. I have some question about whether it works. It can under certain circumstances. There's no question about that. But there are actually other ways to accomplish the same goal without having to use the laws of another state. I could have somebody in a separate property state and with that trust designed correctly, still get a full step up in basis on the death of the first spouse.
Excellent. And here's a question from Paul about finding an excellent local elder law attorney where I live. And John, this is something we talk about on the podcast.
Yeah.
That, you can't just go hire an attorney, right?
Right. Yeah. I mean, so a couple of things. One, there's the National Academy of Elder Law Attorneys, NAELA website, naela.org. And you can go on there and they have a place where you can put in your name. Technically, anybody that's a member of the National Academy of Elder Law Attorneys, they are affirming that at least 80% of their work is dedicated to that area. However, even within the elder law community, there are some elder law attorneys that say only do special needs planning.
Yeah.
They may not do, they may not have any tax stuff. So you also then maybe want to look at their website. Does their website say they do elder law or estate planning? Or does it say they do elder law, estate planning, and 18-wheeler recs? And if that's what they says, you can probably go someplace else because you're not going to do both and do both well, right? And then from there, and everybody that's watching this is already ahead of the game because you go back, you watch this, you take some notes. And when you go and you visit with those attorneys, you ask them some very pointed questions, right? Nobody prepped me for I'm being pitched a Florida community property trust, right. But I was able to answer that off the cuff, no notes, right? Because I know what I'm talking about. So when you go to the NELA website, or maybe you get a referral from a friend, you can ask them about questions like, hey, if me and my wife dies first, is there a way to get a full step up in basis when the first spouse dies? They should be able to answer that question just like that.
Yeah.
All of these, in fact, you could screenshot all of the questions in the comments here and make you a list. And when you're sitting in there, ask them these questions. They should be able to rattle off answers. If they're saying things like, well, I'd have to research that, or, there's been some changes to the law recently, and I'd want to double check before I open my mouth. Yeah, that's probably them working their way around. They don't know the answer.
Yeah. And that's something that we talk about all the time, whether you're hiring an attorney, a financial advisor, or, a tax advisor. ask questions. You got to know what questions to ask. And you're absolutely right.
Yeah.
The comments here have plenty
Yeah.
of those questions.
And you don't have to know the answers to the questions.
Yeah.
You can tell when somebody you're talking to knows what they're talking about by the way they answer your questions.
For sure. Meg has a question here. The horrible tax consequences of an irrevocable trust because of those compressed brackets.
So there's actually, our trusts, if a trust is taxed as a trust, does it have compressed brackets? Yes. It gets to the highest brackets quicker.
Very fast.
But there are 4 different ways that a trust can be taxed. It can be taxed to the person that created the trust. It can be taxed as what's called a simple trust, where all of the income flows out to a beneficiary and they're taxed on it. It can be taxed as a complex trust, which is what Meg here has described, where it has the compressed tax brackets. And it can be taxed as what's called a grantor trust to somebody other than the grantor, meaning that a beneficiary is taxed on the trust at their personal rates, even though no money is distributed. So when you're designing that trust, you're looking at that should be one of the questions, is you're looking at their tax situation and determining, where do we want to shift this tax burden? Do we want to keep it with the grantors? Do we want to push it to somebody else? There can even be reasons, she mentions the compressed brackets. However, if you're already in the highest tax brackets, and let's say you live in California that has a 13% income tax, and you're already in the highest brackets, does it make more sense to put all of your investments into a trust that's based in Nevada? And yes, they're taxed as a trust, but they were going to get taxed at the highest brackets anyway. So that's irrelevant. But you just got out a 13% state income tax by shifting them over to Nevada, right? So it's all about designing that trust in a way. So yes, any workarounds? Absolutely. In fact, you can even toggle these so that one year this person pays tax, one year another person pays tax, the third year the trust itself pays tax, depending on what the tax situation is at any given moment. So again, definitely can be done.
Perfect. And what about moving from state to state?
Yeah. So if you move so first of all, anything that is validly created in one state is going to be valid in every other state. This is why you can go to Las Vegas and get married, and you're still married when you come back to whatever your home state is, right? That's the full faith and credit clause of the Constitution. So if you create a valid trust and will and powers of attorney in California and you move to Colorado, they're still all valid. Now, could there be some reasons that you might want to tweak it, maybe amend it to reflect that it's now going to be governed under Colorado law? Maybe there's some language differences between the states. For example, if I have a client that moves from Texas to Arkansas or Arkansas to Texas, I wouldn't change a thing about it, most likely. I have a client that moves to or from Louisiana, we'll almost always change it.
Yeah.
Right? The terminology is so different from from Louisiana to every other state that you definitely want to, you're definitely going to want to change some of those things.
Perfect. My goodness. There's still a slew of questions here, and I don't know how many more of these we can get to.
Well, of course, they can always, I Mike could even jump into the comments at some point later. And if you do have these questions about it for yourself, you can schedule an appointment with me if you like. And again, that's why that QR code's up there. Since Devin and I have started doing the podcast, I have had the opportunity to talk to people all over the country, and it has been fantastic. So,
yeah. My goodness. Glasses going back on. All right. And I think you've already answered that question again for Meg. You've got this one. We talked about beneficiaries. Some of these are incredibly nuanced. Somebody said nobody seems to be answering the questions in chat. Well, that's what we're trying. We're trying, Carl. We're trying. There's just a lot of them. So too many questions and not enough answers. He came back and said, Carl, you're getting impatient, but that's okay. I understand. Well, good grief. I'm looking at these questions. I'm a little bit overwhelmed. In fact, John, maybe you can jump back into the comments. Guys, this video is going to continue to live. I'm not going to take this one down. It's going to be in my channel. So when you go to my channel, you can just hit the live button and you're going to see those. There's a lot of questions left, and all of these questions deserve an answer. We just don't have enough time, unfortunately, to be able to get to all of these.
Yeah, we'd be here all night, wouldn't we?
We would. We'd kind of set a hard limit of an hour, and here we are at, we're an hour and 5 minutes.
Well, check back in the comments. I will do my best to go through and answer as many as I can. Maybe this evening, maybe tomorrow. I've got a little time on the calendar, but I'll get on there and I'll answer what I can. And of course, you could always, I guess, reach out to us at the Big Picture Retirement and ask questions there. We like to answer questions on the show sometimes as well.
Yeah, for sure. At the top right-hand corner, we have the Ask a Question button. Yep. Fair warning. There's a lot of those too, though.
They do.
And John, I haven't even told you this, but we've got 80-something questions built up.
Oh, wow.
Yeah. So
we're going to have 5 listener question episodes in a row.
Yeah, we're going to have to work our way through some of those for sure. But very good. Well, guys, let's end it right there. John, thank you for coming on the channel. Thank you for helping our audience learning a little bit more about trust versus wills. And I look forward to reading all of these comments and John reading some of your responses there. All right, everybody, have a good evening.